Right, thank you, Mila, for joining us. How's the weather?
It's still a lot of snow.
Right.
Yeah, it's very unfortunate, though.
So, well, thanks for being willing to do this with us anyway. We've been looking forward to your paper. We're running a little bit behind, so we're just going to let you get started. So this is Mila Versteeg, who's joining us remotely. Yeah, I'll just let you introduce your paper and go ahead. So.
Okay, well, thank you very much for listening to me like this. I am very sorry not to be with you because of the snow, unfortunately. And it's always a little awkward to present over Skype, I guess. Am I a giant head in the room? Yeah, okay. Anyway, I'll try not to think about it. So in this paper, I explore if and how international and regional human rights treaties affect constitutional bills of rights. Or more precisely, I ask whether the entry into force or the ratification of human rights treaties makes the same treaty rights more or less likely to appear in national constitutions. So I know this sentiment is shared at this particular conference, but I've presented this paper at law schools before, and I always get the question, why do we care? In fact, I presented this at Chicago, and somebody asked me, why do we care whether one useless document affects another useless document? So just let me say, I guess I just want to start with saying a little bit about what motivates the paper. So maybe we care about this question because the constitutional incorporation of treaty rights may actually improve respect for human rights in practice, right? So as you probably know, there's this whole series of papers that look at the impact of human rights treaty ratification on actual human rights practices. And although the findings differ, probably the prevailing wisdom in the literature is that treaties are most effective through domestic politics. So when they are enforced by courts or when local activists mobilize around these treaties, that's when they are most effective. That's when they make a difference. And that's basically Beth Simmons' work and her book. So it seems intuitive that constitutions could reinforce this dynamic, which is something that Zach and Tom and Beth have also argued. So when rights are enshrined in the Constitution, that may help both local activists and courts. And indeed, I looked into this a little bit. So one thing I found is that human rights treaty bodies often ask countries to place those rights in their constitution. So there's a lot of back and forth between countries and treaty bodies about this. But even setting aside the question whether constitutional incorporation maybe ultimately affects rights in practice, I guess we also maybe care about this question because, there's two other things that the paper tries to do that maybe tells us something about international law that we may care about. So first, the paper tried to distinguish if treaties impact the Constitution. Do they do so because states have to incorporate their treaty commitments, or because they are highly legitimate norms that are just emulated everywhere? So on the first, treaties themselves, all international treaties, actually require states to take measures to implement their treaty commitments. And the Constitution is an obvious way to do so. Indeed, as I mentioned, treaty bodies themselves often ask for constitutional incorporations. So if treaties have some impact as law, if you want, we would expect that upon ratifications, states, the probability of enshrining those rights in the Constitution goes up. However, the constitutional design literature or comparative constitutional law literature has also shown that international human rights treaties are often emulated by constitution makers simply because they offer highly legitimate and authoritative models that the international community as a whole has agreed upon. So if treaties matter through the force of their example, then we would expect that the entry into force or the global availability of these treaties may be enough to spur constitutional incorporation. So in that sense, treaties may matter not as law, but as norms, if you want. And as a footnote, when I talk about norms, I do not necessarily mean that these norms are actually internalized by countries. I'm sort of agnostic about that. It could be something like acculturation, as Ryan Goodman and Derek Kings call it, whereby states do this because it's sort of a legitimate thing to do without necessarily being fully committed to those norms. But in any case, so part of what the paper tries to do is to test whether treaties matter as law or whether they matter as norms. So in the Null Hypothesis, from which the paper starts, is that treaties probably have no independent impact on constitutional rights or constitutional bills of rights. So we know from the literature and various papers, including papers by Zach, that treaties and constitutions actually look similar to each other, but it may simply be that when the treaty commitments already align with existing constitutional preferences or existing constitutional commitments, that's when a country ratifies a treaty. So part of my empirical strategy is that I only look at countries that have not yet ratified the treaty, that have not yet have those rights in their constitution at the time the treaty enters into force or the treaty is ratified. So that way I really try to look at the impact of the treaty on the constitution and not vice versa. At least that's what I'm trying to do. So another thing, the second thing, I guess, that the paper does, which I hope it adds to the existing debates, is that it sort of conceptualizes that treaty rights are not necessarily duplicated in a constitution. There could also be something like what I call a substitution effect. So if rights are already protected under international law, it may simply be less likely to protect them in their constitution. And I specifically set forth the hypothesis that this is particularly likely in countries with a monist system of international law. So I'm not sure if you're familiar with this terminology, but if countries have a monist system of international law, treaties basically work directly in the domestic legal order and do not actually require implementation. So courts can use them directly, use them directly in interpretation. So it may simply be less necessary for monist countries to incorporate treaty rights. And when I studied the reports that countries sent to the treaty bodies, I actually did find some countries responding to the treaty bodies saying, well, we don't have to incorporate our rights in the Constitution because we are monist. Actually, Iran said that, so that's a little maybe dubious. So then the same logic I set forth in the paper also potentially applies to regional systems. So in regional systems, treaty rights are enforced by regional courts, regardless of whether countries have implemented them. So they are structurally closer to monist systems of international law. So I also think that a substitution effect may be more likely in the regional treaties. So I guess I had an empirical model and slides. But maybe if people have the paper, you can look at page 10 of the paper. It's where the model is. I guess this put me, I was going to say a few words about this. I guess that makes me from Mars and not from Venus in terms of the theme of this conference. So I won't say very much, but I guess one of the things that the paper, like in terms of empirical setup, so the paper has 3 dimensions of variations, or which is it explores variations across countries, across time, as well as across different constitutional rights. So the dependent variable consists of 186 countries, 61 years, I believe, and then 103 constitutional rights. And these 103 rights are basically a fairly exhaustive list of rights that are adopted by at least 5% of all constitutions, but not all of which actually appear in the main human rights treaties. So that's sort of the dependent variable. I construct the dependent variable in such a manner that it's 0 in the year prior to adoption, 1 in the year of adoption, and missing afterwards. So it's basically an onset model. And it's my hope that that sort of deals with some of the concerns over reverse causality. So on the left-hand side, I'll be very brief. So that's the left-hand side. On the right-hand side, so I look at the impact of 7 international human rights treaties and 11 regional treaties and optional protocols. So there's 2 variables that are, I guess, the ones, or 2 sets of variables that are the most important ones. So the first is a set of interaction terms that interact the rights that are in the treaty with the year that the treaty entered into force. So they capture sort of the global entry into force of those treaties. And then the second is a set of interaction terms for each treaty, an interaction term for each treaty that captures the rights that are in the treaty, as well as the year in which the country ratified the treaties. So here, it's a variable that basically varies across time, across countries, and across constitutional rights. And you can think of this as there being 2 control groups. So first, there's those countries that didn't ratify the treaty. So they shouldn't be more likely to adopt those rights in their constitution. And second, there is the control group of the rights that are not in the treaty, so they shouldn't be more likely to pop up in national constitution. Well, of course, those control groups are not random. And I spend a lot of time in the paper talking about that and trying to deal with that. So, I mean, Beth Simmons has pointed out, and I sort of rely on this in the paper, that most countries have relatively little influence over which rights actually appear in the treaty. So you could say that the entry into force of a new treaty is somewhat like a global shock to the international system. It's somewhat exogenous. But of course, ratification is not, right? So, and I try to deal with that in various ways, mainly just brute force, a lot of fixed effects. So I guess I'll just use 1 minute to tell you what my main findings are. I haven't really kept track of time. Tell me if I...
Yes, that's about what you have, 1 minute. So.
Perfect.
Yeah.
Okay, so my main findings are as follows. So I found basically a fairly limited effect of international human rights treaties on constitutional bills of rights. But there are some exceptions. So I find that the ratification of the the second optional protocol of the ICCPR, which abolishes the death penalty, as well as the optional protocol to the European Convention that abolishes the death penalty, both make countries more likely to abolish the death penalty in their constitution. So here you find some effect of human rights treaties as law. Notably, these are very specific commitments, and I guess it would be, if countries do not actually constitutionally incorporate that commitment, it would be a highly visible sign that they are not living up to their constitutional treaty commitments. So then the second thing I find is that there's two treaties that seem to affect countries everywhere through their entry into force, and those are the Convention Against Torture and the European Convention on Human Rights. So when the Convention Against Torture entered into force, countries everywhere were more likely to prohibit torture in their constitution. And the same for the rights in the European Convention on Human Rights after it entered into force. Which is actually, I sort of liked that finding because it was somewhat consistent with accounts in the literature, sort of historical, qualitative accounts that I've read. Notably, the paper doesn't look at the Universal Declaration on Human Rights, which another conference paper looks at. So then the other finding I have is that in countries with a monist system of international law, I actually find that there is a substitution effect for many of the core human rights treaties, so these countries are actually less likely to place those rights in their constitution, whereas in the dualist system there is some effect of ratification. So that's, I guess, goes to that. So I find some evidence for that hypothesis. And then I find that for regional systems, specifically the European Convention on Human Rights and the Inter-American Convention, and some of their optional protocols, there is also something like a substitution effect. So these are some of my overarching findings. I'm very curious to, I know there's a lot going on in the paper, and I'm still thinking about, is this the right way of framing it, or should I go down, to try different things. So I'm very interested in your thoughts, and I hope this was somewhat clear in terms of the Skype presentation.
Right.
Thank you.
Right. Thank you, Mila. So we have comments from Cindy Ewing, who's a Ph.D. student in history at Yale and is visiting us for the semester? For the year? For the year. So,
Okay.
Do you know each other?
Yes, we
Okay,
actually
great.
overlapped at the University of Chicago while she was an Ewing fellow, so we already seen one another. Should I do it this way, or should
Yeah,
I
that's
let
fine.
it
Yeah,
go?
no, that's good.
So this way, I've already circulated the comments to Mila so that in case things cut out.
You
she
should
already
bring
knows.
your microphone a little closer.
Okay. Is that okay?
Yeah.
Okay. So Professor Versteeg offers new findings and a fresh take on the question of how international human rights shape state behavior. Rather than dwell on the issue of compliance, which animates a large part of international law scholarship today, her research looks earlier in the process to the incorporation of the treaty right. She asks, when do states adopt treaty rights into their constitutions, and takes into account the probability of adoption before and after ratification, the ability of the government to amend its constitution, the influence of domestic political forces, and variations in preferences. This attention to direct incorporation presents a clearer picture of one particular dimension of compliance that is sometimes passed over in favor of the more politicized task of scrutinizing behavior after adoption. Professor Versteeg argues that the constitutionalization of treaties can help us parse the difference between human rights as norms and human rights as law. By distinguishing between constitutional changes following ratification and following the treaty's entry into force, she sheds new light on what independent impact human rights treaties may have on written national constitutions. In other words, she furthers the debate by clarifying its own terms. She makes the case that we should care about constitutional incorporation because it is a public and highly visible signal of good intentions. Not undertaking this step would certainly lower the prospects for good human rights practices, especially if you accept that constitutional rights strengthen courts and civil society. However, since the overall thrust of the research findings is that treaties do not have an effect on the Constitution, the conceptual puzzle still stands. How seriously should we take this step of emulation? Does the expression of treaty rights in the Constitution make more than a symbolic difference? One of Professor Versteeg's distinctive findings is the relevance of the status of international law in the domestic legal system, by which dualist countries have an increased probability of incorporation, while monist ones have a decreased probability. Monist countries, mainly in Latin America and Europe, tend to substitute treaty rights rather than repeat them. And in the case of regional human rights treaties, substitution emerges regardless of whether the country observes dualism or monism. Where treaty provisions need to be translated into domestic law, ratification has the impact of committing constitutions to the equivalent treaty rights. This would support the law-based explanation that states constitutionalize their treaty obligations upon ratification. If the highly visible nature of the Constitution motivates this domestic implementation, then a speedy process would be of the essence. But in reality, there's great variation in how long implementation might take, if at all. Moreover, there is variation in the treaties on what such implementation would look like. Is there a correlation between domestic implementation and those treaties that specifically recommend incorporation into the Constitution? Given that the most powerful examples of emulation occur without ratification, can we draw any significance from ratification as a point at which governments are spurred to amend their constitutions? The interpretive puzzle here is when there is an independent impact. Is it significant enough to generalize about the effectiveness of the treaty overall? For example, looking outside the study, given the immediate statutory effect of international treaties in a place like Morocco, and that when there is a conflict between domestic and international law that the latter prevails, does the substitution of rights into Morocco's constitution tell us anything about how Morocco treats its treaty obligations? Can substitution mean that the Constitution is instead bypassed and that international law immediately becomes the law of the land? To me, the substitution effect could be a powerful way to enshrine international human rights, but on the other, it can be a way to enable flagrant rejection of human rights. Can we read the state's actual behavior back into the emulation? Or how about countries that are not strictly monist or dualist, such as Bahrain? How does that complicate the model? When the research affirms the intuition that international human rights treaties do not have an effect on the Constitution, does it matter for the sake of human rights protections what the translation of treaty language into constitutional commitments looks like? Because the study excludes the roles of judiciaries or legislatures in interpreting and implementing treaties, we don't know how substitution is expressed in real-life terms. What should we infer from those states that are less likely to incorporate when treaty provisions must be translated into national law through the legislature? Is the dualist approach an obstacle to treaty incorporation? Professor Versteeg concludes her paper by suggesting that the substitution effect she observes could actually be harmful to de facto rights in practice. But this may be granting the constitutional provision a role in the human rights promotion that it may not have. As she acknowledges, it may depend on the strength of the treaties and constitutions in enforcing rights, returning to the problem of compliance rather than that of incorporation. I was also curious as to whether international treaties influence a state to act more monist or dualist, perhaps by ceding to the universality of human rights norms and sounding more monist, or when courts might invoke self-execution to limit the domestic effect of ratified treaties. New Zealand is traditionally described as having a dualist approach to international treaties and a monist approach to international custom. Do contextual differences pose any issues in the coding? I would also like to know more about the findings regarding torture and the death penalty, and how we know that these exceptions don't tell us more about torture as an issue of international concern rather than the effectiveness of the treaty to model prohibitive language against torture. While we ought to acknowledge that whether the treaty is fulfilled in practice is beyond the scope of the study, the question of whether constitutions can serve as channels for treaties seems to be undermined by the role of international courts in the regional context or local activism in the domestic. Her paper accounts for omitted variables. to push back on this aspect of the study. Is there a difference between constitutions that predate the creation of international organizations or lack provisions on international law? How about countries that historically are resistant to constitutional change? Do different adoption procedures matter? One of the only countries to incorporate the ICERT into domestic law completely is Greece, but there is hardly any case law relating to racial discrimination. Is there any advantage to incorporation over domestic legislation or provisions for enforcement? What is lost by excluding courts from this process of extending human rights? The larger question seems to be whether treaties protect rights at all, and if they do, is the Constitution part of that? But could we rephrase the question to ask if there are different kinds of constitutions or constitutional systems that are more open to treaty influences? Moreover, doesn't this framing favor countries that regularly amend their constitutions? And how are failed amendments that may be offered but not approved figured into the model? How would Professor Versteeg's term of rights creep factor into the findings? Now, it would be unfair to ask Professor Versteeg how historians might take stock of her work, so let me offer a few suggestions, though her thoughts on this topic would be very welcome and salient to the purposes of this conference. Treaty negotiations and constitutional histories don't make for thrilling stories, so historians of human rights have tended to focus on how rights emerge locally, favoring the sub-constitutional domestic environment. But Professor Versteeg's paper poses an important challenge to historians. Where the international human rights regime has shaped the interactions of states with their citizens, the Constitution is largely omitted, instead dismissed as a document of elite production at the exclusion of non-citizens. But as Professor Versteeg notes, constitutions are themselves constructed national products, reflecting processes of negotiation and contestation in multiple arenas towards shaping those constitutional commitments. Would historical inquiries spur further scrutiny of the context to uncover other variables that may have an effect? One space in which this paradigm is complicated is in new constitutional systems, most often post-colonial nations that emerge after many international treaties have been written. The intertwining of these national histories with the expansion of international law may teach us about how constitutional designers think and incorporate international norms, designating constitutional rank to rights or legal status to citizens and non-citizens. While the study codes for reverse causality, one wonders how relationships among states would influence actors in their place and time to sign and adopt treaties, and then translate those commitments to a national audience, perhaps passing the baton from the empirical to the contingent. Context would supply a better understanding of the differences among those delegations that might be writing and shaping international treaties from those political leaders who are signing them. Professor Ona Hathaway has made arguments against using a qualitative method in favor of a quantitative one. Constitutions also have different values in different places. The importance of the Constitution in both the national political imagination and in the regular conduct of legislative affairs might further untangle how constitutional rights might compare to treaty rights. The process of incorporation thus needs more description as it's carried out to support groups and manage levers of power. To what extent would this substitution effect that Professor Versteeg discovers in her research really figure into the minds of those concerned with human rights, when human rights capture far more than laws alone, but also discourse and politics? When do rights leave the realm of the aspirational and become realized? It is not a coincidence that histories do not take the treaty as the starting point. Historians may take that treaty-constitution relationship as intervening in the middle of the story, detaching commitments from the availability of those promises being fulfilled in practice. That we don't have good histories of human rights constitutionalism to converse with empirical studies such as this one. To consider the issue more carefully and precisely, therefore, would certainly be in the interest of offering a fuller history of human rights.
Great, excellent, thank you.
Thank you very much.
And very much on time. So now, Mila, as we've been working under the Texas rules all morning, so now we're going to turn to the Greek chorus. And hopefully, if they use a microphone, hopefully you can hear us quite well. Let us know if you don't. They'll give us very brief reactions to your paper, and then we'll turn to the audience, and then you get to respond to both the Greek chorus and the audience at the end.
Thank you.
Hi, I'm Kiyo Futsui.
Oh, hey.
Hi. Really nice to meet you. Really enjoyed the paper. Great, thank you. Really enjoyed your paper, and I think it makes a great contribution to the literature. One relatively mundane and minor issue that I'd like to raise. It's about, well, I don't mean to push my own intellectual agenda, but since you refer to the world society approach, which is my intellectual background, we tend to look at, especially making a distinction between your first argument, norm-based explanation, and the third argument, interest-based explanation, we tend to look at exposure to global norms. Global norms tend to have more impact in countries that are more tightly linked to international society. So we use linkage variables such as international NGO membership, international government organization membership. So and your way of doing this actually works for you. So I don't have any complaints about this, but I wonder if you tried that, those variables, how might the findings be different?
Hi, I'm Julieta Lemaitre. I'd like to hear more on why you think that this is relevant for implementation on the ground. Like, what are the differences between countries beyond the fact that they have different systems? Does it extend to other aspects?
Hi, I'm Paola Vergallo from Argentina. I enjoyed the paper, but I have two minor questions. I'm a lawyer, so I have a question whether you have differentiated the way in which the treaties are incorporated into the Constitution, because there are some countries like Latin America where there is this block adoption or incorporation, like in Argentina, and I wonder whether that makes any difference at all. I also wanted to ask you, you assume the legitimacy of the treaty just because they have been ratified, but in fact, like when we lawyers study treaties, we know that there are a huge difference among the legitimacy of the different treaties. So CEDAW, it's not GATT, and that's obvious. And I don't know whether that is an endogenous thing. The treaty doesn't have the agreement behind it that the GATT has. So just.
Hi, I'm Courtney Young. I have a question about the relationship between the monist systems and economic and social rights. And I'm wondering, I just want you to explain how the monist systems, how you found monist systems have fewer economic and social rights, or what the relationship, or, you know, how there's a substitution effect in monist systems. Not how, but how can you explain that, given that monist systems are where you find most economic and social rights?
Hi, Mila. I've got, as you might suspect, a couple of methodological questions for you. And the first one is, how concerned are you about heterogeneity? I guess my concern here is that different countries are going to adopt these things in their constitutions for different reasons. And I appreciate the kind of monoism distinction there, but I also wonder if there's other forms of kind of heterogeneity that you're sort of missing. The kind of big one as a comparativist is regime type, but even kind of more fundamental than that are things like colonial influence, right? Like the African constitutions. Those constitutions were written, some of them at least, after these documents came into force, so kind of what implications does that have, et cetera. And they're also more dependent on the international community for aid and whatnot, so how are you accounting for that? The other thing that I wanted to bring up, if I can remember it, is you're assuming that these treaties have a direct influence on these constitutions. You can't account for, in your current modeling, the indirect influence of these treaties. And so I just wonder if you've thought of estimating some sort of structural equations model or something like that that might allow you to get at some sort of indirect influence where maybe early on when these things were first ratified or first came into force, they were highly influential, but that's kind of dissipated over time, right? And so just thinking about other kind of mechanisms for influence in a way.
Great.
So that's the first round from the Greek chorus. And now we go to the audience. I see Zach here and then Judson in the back. So we'll start with Zach.
Hi, Mila. It's nice to see you. You're coming through loud and clear. It's as if you were here. It's great. So I guess I want to follow up on something that Cindy mentioned and that James alluded to as well. I'm wondering about the opportunity to actually incorporate these things. Because as I think about your paper and I think about the paper that Tom, Beth, and I had, there are different results. And I think one way to square them might be that I think our unit analysis in that paper is such that you can deal with opportunity. So I'm thinking that, of course, those constitutions that have the opportunity to replace or even revise more easily after signing these treaties would then have an opportunity to put them in. And, just to think about this in the case of the United States, we signed the ICCPR in 1992, and that is, of course, the year of our last and our 27th Amendment to the Constitution, and the chance that any of these rights that we don't already have make their way into our Constitution is about as close to zero as anything I could imagine. So, doing some of the things that I think Cindy and James suggested in terms of building that in either by changing the unit of analysis or using a moderating or conditioning variable that allows you to look for that joint effect of ease of amendment and having signed might be worth doing.
Yes.
Yeah, I think that if we're talking about the impact of human rights treaties on constitutional rights, we should also be aware of a very powerful organization, treaty organization, that could care less about human rights and explicitly condemns all various forms of human expression and activities such as excessive religiosity. I'm talking about the Shanghai Cooperation Organization, made up of Russia and China, with about 4 of the Central Asian countries as members, with a variety of countries trying to become members of this organization, including, as far as I know, India and Turkey. This really is a way of China's asserting its increasing control over Central Asia, which incidentally might explain the Soviet, the Russian desire to hold on somehow or other to Ukraine. But this is clearly anti-human rights. It's clearly powerful, and is backed by both Russia and China. China is the dominant partner.
Anything else from the audience? All right. Well, Mila, your turn.
Oh, wow. There's a lot of comments to respond to at once. Let me just, I guess, go back to the beginning of the chorus. So the question, and I may miss some comments, but I'll try to, answer as many of them as possible. So, the question about exposure to global norms and whether or not that makes a difference, I think is a very good one. I'm familiar with that work and sort of world polity literature. I haven't really thought about this in the context of the paper, but actually I could consider doing that and see whether those countries that have more international NGOs in their country, right, is how you operationalize this, whether they are more likely to be receptive to those norms. That may actually be very interesting. So thank you for that suggestion. So then there was the question, I guess there were various questions about whether there were other differences that among countries. So I guess it was partly what James was saying, regime type, and partly also what Zach was saying, and Cindy, that the ease of amendment is potentially a problem, or some countries it may actually be possible to incorporate treaty rights in their constitution, whereas for others it's not. So let me say, the very unsatisfying answer, or at least one very unsatisfying answer I have, is that my model includes country year fixed effects, which means I control for everything that's particular to a particular country in a particular year. Which doesn't mean that these things don't matter, it just means that I just ignore them and try to control for them. Right? So to the extent that you cannot amend your constitution because it's very hard to amend it, that's captured by the country year fixed effect. Well, maybe, but it's sort of a brute force strategy. I just put everything in my fixed effect. So there is a question maybe that should be something, maybe this is something I should explore more or see whether there is differences along those lines. I mean, the only thing I'm worried about is that maybe the paper would then really do way too much, so maybe that's something like more along the lines of a follow-up or something like that. So James, one response to you though is that I did look at whether there is a difference between democratic and autocratic countries, and also specifically, which is something like Beth has shown in her work, to transitioning democracies and whether they may be most prone to put those rights in their constitution, because her book, that Simmons book, also shows that those countries are most likely to uphold their treaty commitments in general. But I did not find any differences there. So I did explore a little bit more and looking whether there's other sort of non-linearities in the data that may explain this. And I found that the most important difference was the monist versus the dualist system distinction. So at the same time, and I guess Cindy was partly saying this, and the person who identified as a lawyer was also asking me about this. So how do we really know whether a country is a monist or a dualist system? And I think currently the paper is not super satisfying in that respect. So what it does is it actually relies on the coding by the Comparative Constitutions Project to look at what the Constitution says about this. But then many constitutions are silent on the matter, so what I did next is simply assume that if you're a civil law country, you must be monist, and if you're a common law country, you must be dualist, which I don't think is very satisfying. So I'm actually currently undertaking a project together with Pierre Bourget, my colleague at UVA, and what we're doing is we're trying to map extensively for each country how they deal with international law in their domestic legal system, not just looking at the Constitution, but also looking at court decision and all sorts of regulations, the Foreign Relations Act and those kind of things, to get at not just whether a country, whether treaties need domestic incorporation, but also distinguish between treaties and customary international law, as Cindy has pointed out. And also there's differences across countries in terms of what status those treaties really have, right? So sometimes treaties are incorporated directly, but they're inferior to ordinary legislation, whereas in other cases they're superior to ordinary legislation, and in some cases even superior to the Constitution. So I think this is partly a response to Cindy, is that hopefully, it's a lot of work to collect those data, because we actually have to read a lot of court cases, etc. But hopefully that will give me a little bit more context along the line that you seem to be interested in here. So then I guess that leads me into the question about social and economic rights in civil law countries. So I think you're right that civil law countries do generally have more social and economic rights. But I do think most of them already had them by the time these treaties went into force. So I think there's sometimes a bit of a misperception in the literature, at least not the literature that I read, which may not be written by proper historians, I guess, where people think that sort of social and economic rights only take off after the Second World War, and I don't think that's correct, right? I think in Latin America they really were adopted in the early 19th century, also continental Europe, so I think they really proceed. In many cases they were already there, so in that case I don't really find an impact of the treaties alone, and to the extent the treaties added anything to the things they already had, then they're less likely to do it, I guess, is sort of the story. But I don't think it's necessarily inconsistent. But I do agree with you that civil law countries tend to have more social and economic rights, which is not the same as entirely the same as monist countries, but there is a correlation there. Let me see. I guess I missed a number of comments. Oh, yeah, so somebody asked me about whether if I looked at some constitutions that actually directly incorporate international human rights law wholesale, and I did actually look at that, and I looked at whether the effect of those, I mean, there's a section in the paper somewhere near the end where I look at whether those countries are different or are different in terms of whether or not they also repeat those rights in their constitution, and I exclude them, and I don't think I found that it didn't really affect my findings very much or at all, but it's obviously an important thing to take into account. I guess I'm not entirely sure. Oh, yeah, so I didn't really entirely respond to James's question. So indirect influence, yeah, I would love to talk to you more about that. I guess I know you're thinking about these same questions. I guess my short answer is I'm not necessarily sure how I would bring that in for this paper, what sort of the indirect influences of those treaties are. I mean, I have other work where I look at whether countries influence each other. So it's possible that some of this is like one country, one influential country puts this in its constitution, and then there's somewhat of a diffusion project, sort of diffusion process going on, and then as a result of that, the rights spread, but it's not directly the treaty that does that, right? So maybe what I should do is include spatial lags in this model. This is something I've thought about to sort of see whether some of it may be countries subsequently following each other as opposed to the treaty, which is something I could do even with my country year fixed effects. But yeah, maybe it's something I would love to talk to you more about at another occasion. So then I guess, I'm not sure, how much more time do I have?
You have one more minute, really, just one more minute.
One more minute. Okay. Well, I really thank Cindy for her comments. I thought they were very useful and excellent. Yeah, so I mean, I would, this may not be the right place, but I would like to, I mean, so there's different questions that different things that I wanted to respond to of things you said. So one thing is, so how serious do we take emulation, right? What if they just simply emulate and have no real intention of doing anything with those rights? So here, I think actually that made me think of James' paper on the Magna Carta. So this is like one treaty or one very important document that wasn't very important at the time it was adopted. It became very powerful over time. Right, so the Magna Carta is a document that was possibly useless at the time it became more important. So potentially, right, even if we think that some of this emulation of treaty rights in the Constitution is not very powerful, it could become more powerful over time, is something I have to say. I mean, people sometimes talk about the Egyptian Constitution of 1971 as the joke that turned serious. Nobody really meant it to mean anything, and then it became more powerful with time because NGOs started using it, etc. So that's sort of the constitutions can be sham, they can be meaningless, but they can become more meaningful over time. Exactly true domestic politics, for example. Another thing, I mean, I really like your suggestions of how historians would think about my paper. I mean, one thing that I would love to talk to you more about, which I found puzzling, is that you said that historians don't think that looking at the history of treaty drafting is very interesting, because it seemed to me that should be very, and that they focus on local stories. So I was sort of interested in why don't historians look at the international story then, if that's true, right? It seems that there is a lot of interesting conversation to be had there. I guess I should just stop here because otherwise I'm going on for too long. Yeah, but thank you very much, though, for this
Thank you very much, Mila, for being willing to participate.